Very good. Mr. Eisman, we have you. And Mr. Rocknick, you just need to turn on your video. Very good. I think we have you both. All right. Excellent, everyone. All right, gentlemen, we're ready to proceed with the Dolphin Aviation versus Heli Aviation of Florida. We have on behalf of the appellant, Mr. Nick Rocknick here and Mr. Derek Eisman here on behalf of the appellee. And gentlemen, to remind you, 20 minutes apiece for the argument. Mr. Eisman is the appellant. You are provided up to 5 minutes for rebuttal. How much time do you wish to take?
Your Honor, actually, Nick Rocknick for the appellant.
Mr. Rocknick, I was looking at Mr. Eisman, and I've been meaning to say it's Mr. Rocknick. I apologize. He's showing up on the left, which is no problem.
Yeah, somehow he snuck in there.
I apologize, Mr. Rocknick. You are here on behalf of the appellant. So how much time do you need for rebuttal, sir?
5 minutes, Your Honor.
Very good. Thank you, sir. All right, you may proceed.
Thank you. May it please the court. Again, my name is Nick Rocknick, and I represent Dolphin Aviation.
Oh, and I mispronounced your name. I apologize. So how'd you pronounce it again? Rocknick.
Yes, my mom says Rocknick, but I say Rocknick, so it's probably okay either way.
All right. Well, I'm happy to do whichever way. So I will do it the way you'd like it, Rocknick. So I don't remind you of your mother. How's that?
Thank you very much. Right. This matter arises from the trial court's interpretation of a provision in a commercial lease. Dolphin Aviation is a fixed-base operator at the Sarasota-Bradenton Airport. They have a master ground lease from the airport authority from which they sublet hangars to various businesses. Heli Aviation, the appellee, has been a subtenant for several years. The lease from Dolphin to Heli is a very simple one-page lease, and it is in the record at our page 94. The lease provision, which is the center of this appeal, is a provision that's titled discretionary termination. The one-sentence provision states that should the lessee breach any of the terms and conditions of this lease, or should the lessee operate its facility in a manner that reflects unfavorably upon lessor or its operation, then the lessor shall have the right to terminate this lease upon 30 days written notice.
So, Mr. Rocknick, would you agree with me that this provision is very, very broad, correct?
Yes, Your Honor.
It gives your client the right that if your client feels that something reflects unfavorably to him, that he has the right to terminate. Is that what I'm understanding you and your brief?
That's true.
I would call that it's either my way or the highway provision.
Yeah,
it is. And one of the things that was brought up in the hearing and the president of Dolphin Aviation testified to was that it parrots the language of his master ground lease. The airport authority has the same discretionary termination provision in their lease.
But it is what it is, and that's what was negotiated for and what everybody signed and agreed to, right?
That's true, Your Honor, and there was never an issue of unconscionability raised. It's the bargain.
Whoops, I think you just froze, Mr. Rocknick. We'll give a minute, maybe hopefully you'll unfreeze. Can you hear us, Mr. Rocknick?
Of parties, but my screen as to you is froze too. But is it? Okay,
we're okay. We missed what you just said. Now you're unfrozen. Now you're fine.
Yeah, I'm sorry. The computer said that the connection was unstable, but maybe it's okay now.
No problem. For whatever reason, Mr. Rocknick, we lose you. The phone number that we have that we provided you, feel free to call in. We've had oral arguments with some lawyers for whatever reason because of the internet. So don't worry, we will get with you. So
I appreciate your patience on that. And I'm not quite sure where I froze, so I might respond again. And the Dolphin Aviation, as a tenant to the airport authority, has the same provision in their lease, in the master ground lease, that says that the airport authority has discretionary termination rights, which could be triggered on the discretion of the airport authority. And that's the same language in the sublease with regard to the subtenant Heli Aviation.
And Mr. Rachik, let me get you, because the posture of this case in the record is that the court below basically granted an involuntary dismissal. That's all that's before us. It's the grant of involuntary dismissal. So for purposes of our review, we have to determine whether or not there's enough evidence presented that will withstand the involuntary dismissal. You agree with our standard of review at this point, correct?
Yes, Your Honor.
So now we get to look at what was provided at the evidentiary hearing. And it's your position, as I understand you, that by virtue of you receiving that letter, just that letter from the airport, that by virtue of receiving that letter alone, your client saw the letter and came to the conclusion that's an unfavorable, I look bad in this letter. And because I look bad, then I have every right, given the broad statement of the lease, to issue a termination. Is that correct?
If I may respond to that in two parts. One is that as the landlord, of course, when his business is to sublet hangars, it is his desire to have tenants. So it's not that he seeks to get rid of tenants for no reason. In the letter, that it was admitted for purposes of how it impacted Dolphin Aviation. Excuse me, and in the record at page 99 is the second page of that letter. And I want to read it just because it addresses, I think, maybe your concern with regard to what it was he received. Because the last paragraph of the letter, which comes from Frederick Piccolo, he's the CEO, president of the Airport Authority, and the letter says, only your removal of Heli Aviation and its principal and manager, Nicholas Hurley, from the airport will cure this default. And they're referring to the default between the Airport Authority and Dolphin Aviation. And unless it is cured by August 16th, 2019, the authority will enforce implementation of Articles 8A and 8B, and the reference agreement will be terminated. No further notice is required to be given. So it's basically the notice from the Airport Authority that told Dolphin Aviation, if you don't take action to remove this tenant and its principal from the airport, you're in breach of your lease agreement. So I think it goes to a greater extent than simply a letter that seems maybe irritating or maybe inconsequential in some respect. This is the entire business of Dolphin Aviation. Without the ground lease at the airport, they have no business whatsoever, and they're being told by the CEO, principal, president of the Airport Authority, if they don't take action to remove Heli and its principal, Nicholas Hurley, from the airport, that their lease would be terminated. So it wasn't I don't think it's simply an inconsequential letter. It's actually a very significant letter, and the letter goes on to list a number of violations. Of course, the purpose of the letter wasn't introduced for trying to prove criminal activity. There's an allegation that he pointed a loaded weapon at a customer on the airport land. The letter wasn't admitted to prove or disprove that. The court, in its ruling, did find or did accept that there was a bench warrant out for the arrest of Mr. Hurley. So it's not inconsequential, the actions of the tenant. And again, going back to the first point, the last thing that Dolphin Aviation would want to do is try to get rid of its tenants. It actually goes to find tenants and would like to keep its tenants. But in this circumstance, it was essentially required to pursue the eviction.
I'm curious, Mr. Arthur, what was the judge's ruling? In reading through what was provided to us, I got the impression that the judge felt that it was your burden to bring in evidence to show criminal activity, to show any of these wrongful acts. But when I always like to go back to the contract itself. The contract itself is very broad. It says you don't need to make all that proof. All you have to show, and again, we're dealing with just a sufficiency, enough for an involuntary dismissal. Is there enough that would be unfavorable? Unfavorable, that means anything. I mean, going to the extreme, if somebody says, oh, you received something that makes you look bad, hey, I received something that makes me look bad based on the terms that you signed, I could boot you out. I mean, I'm being simplistic, but the actual terms of the lease gives your client that right, correct?
Yes, Your Honor. And if I may, just cite right to the case law that was cited in the brief as well, and it's in the Richter case, and I don't know why it seems that marital disputes seem to be a breeding ground of contract issues, but both of the cases we cited to originate out of marital disputes and property settlement agreements, but contract law is applied in Richter, and it's at page 4 of the case. It says that in the absence of ambiguity, the party's intent must be discerned from the four corners of the document. Where a contract is clear and unambiguous in its terms, the court may not give those terms any meaning beyond that expressed. Thus, the language itself is the best evidence of the party's intent, and its plain meaning controls. Now, I'm not going to say that the provision that you see on the one-page lease is disadvantageous to the tenant, because I think it is. And in hindsight, they may want to renegotiate that the next time around, but the fact of the matter is it is a bargain for term of the contract. There was no finding by the court that the discretionary termination provision was ambiguous or unclear. And in that Richter case, it says the regulatory power of the state of Florida is not available to affect, modify, or change the bargain of the parties. Thus, a judge must enforce the parties' agreement when called upon to do so, but that judge has no power to rewrite their agreement. And as tempting as it may be for the lower court to rewrite the agreement and make a determination for cause or require some further justification, it's not what the clear and unambiguous language of the lease says. And it was also, the Richter case was also cited in another, in a Florida Supreme Court case, Hamovich, which we cited in the brief. And the Supreme Court said where a contract is clear and unambiguous, it must be enforced pursuant to its plain language. In such situation, the language itself is the best evidence of the party's intent, and its plain meaning controls. In Your Honor, you cut right to the chase of the entire argument, because as potentially disadvantageous to a tenant as it may be, it is the clear and unambiguous language. And the position of Dolphin is that when they receive that letter, they can invoke the discretionary termination provision, which is what they did. They gave the 30 days notice. And with the ruling in the court, I'm sure that your question was referring to the judge's ruling. He says, in order for the court to find discretionary termination was justified, the court would have to find the lessee operated its facility in a manner that reflects unfavorably upon lessor. It's really not what the court needs to find. The clear and unambiguous terms of the contract are what need to be enforced, and the court really has no power to rewrite, as much as they may feel empathy for the tenant or think that it's maybe not a result that the tenant would choose. It's still what the terms state in the contract. The discretion is the discretion of the landlord. And where it's clear and unambiguous, then really can't rewrite it to include that it has to be for cause, or that there's a justification required, or that the landlord's discretion itself has to pass muster with a subjective test of whether it's justified or not. It's as simple as the lease provision that states discretionary termination, giving the landlord 30 days written notice. It's clear and ambiguous term of the contract. There's no dispute as to any facts. The letter was admitted only for the purpose of showing the mindset of Dolphin and why they felt it necessary to take action. Now, maybe addressing a second issue, the court at the end of the evidence couched that in terms of an involuntary dismissal, but I think in an involuntary dismissal, really not supposed to weigh the evidence. It's supposed to be based on whether a prima facie case was made. And in this instance, by invoking the provision of the lease and terminating it specifically pursuant to the term of the lease, I think certainly it passed the test of whether a cause of action was stated. And so to dismiss it as an involuntary dismissal with prejudice, weighing evidence was compounding the error.
And actually, you're about to get into your rebuttal time, Mr. Rocknish. Would you wish to you could proceed right now, or if you'd like to save the remainder?
Well, Your Honor struck right to the heart of the matter, and really it addressed what I was going to raise anyway. So for the reasons that have been presented, the answers to the questions, I'd respectfully request that the court reverse the order of dismissal with a prejudice and remand the action proceedings consistent with the case law, Hahamovich and Richter. And I'll keep the reply very short. Thank you, Your Honor.
Okay. Thank you, Mr. Rocknish. All right, Mr. Eisenman. I'll tell you, you've heard my questioning of counsel. Let me see if I can get to the heart of it. I know what I'm concerned with. Why doesn't the letter, which was admitted into evidence for the effect on the listener, as counsel indicate, constitute some affirmative evidence that he lied, that he operated the facility in a manner that was reflecting unfavorably on Dolphin?
Sure. The letter was admitted specifically for the effect on the recipient subsequent to the time that he received the letter. As you'll note, the letter was dated in July of 2019, whereas the notice for this eviction was in June of 2019, prior to receipt of that letter. The lease clearly says that to terminate, they have to provide notice, 30 days of written notice after there's some default. So in this situation, the only evidence before the court was the effect of the letter subsequent to the time of receipt. And therefore, there was no evidence in front of the court to show a default that would trigger that 30-day notice that was filed in June. There was no violations of any airport rules or regulations that were admitted that the court accepted, and nothing to show that the operator, which was the corporation, was operating the facility unreasonably.
Well, let me ask you a question, Mr. Eisen, because there's two provisions in this discretionary, termination. It says either should lessee, and let's break it. It's or, so it could be either one. Number one, the lessee break any of the terms and conditions of this lease. That's number one, but we're not going through that. It's a second, that should the lessee operate its facility in a manner that reflects unfavorably upon the lessor. So that goes back to my initial question of counsel, that if anything that's presented rightfully or wrongfully, without getting into the substance of it, and I come to the conclusion, if I am the lessor, that, oh, this makes me look bad, this is unfavorable to me, I have every right, based on your client signing off on this document, to proceed with termination. Correct?
I think there's a distinguishing factor in that there wasn't a sole discretion. It wasn't in the landlord's sole discretion. It was just it's titled as discretionary termination in the headline, but nowhere in the body does it reflect that it has to be solely in the landlord's discretion.
Look at the language, the exact term, as you know, a contract, it has to be strictly construed, and we cannot really inject any other term. But the language here says, should the lessee operate its facility in a manner that reflects unfavorably upon the lessor or its operation. That's really, really broad. This is what we're dealing with. This is a provision that your client signed off on it. So based on that, it could be anything that would reflect unfavorably. If there's any evidence presented to the court, and especially on an involuntary dismissal, isn't that sufficient?
And I guess just to inject here before you answer, Mr. Eisman, just to follow up on Judge Kazam's question, is it your position there was no other evidence entered except for this letter which came after the default your client received? Is that your position?
That is our position.
Okay, so there was no witness took the stand and said anything with regard to the plaintiff's position that your behavior is causing us concern. Nobody
Correct.
said that. Okay. So, and the sole piece of evidence was this letter from the airport, which post-dated the default letter your client got.
That's correct. There was only three pieces of evidence admitted, and that was the lease, the notice of termination from June, and then this letter from July of 2019, which was admitted only for I guess how it impressed the landlord in this situation, but didn't get into the details of any of the facts or factual allegations inside that letter. So no, there was nothing prior to that time, prior to the default letter that was sent, that indicated that the lease was breached. And I believe the trial court even made a specific note of that, noting that there are these factors out there, there are these, arrests, but I cannot take those into evidence of where they occurred, how they occurred, what occurred. The only thing I can look at is the evidence that's been admitted to me today.
But if I may, Mr. Eisman, isn't that by itself, I know the letter was after the fact, but doesn't identify conduct that was taking place prior to the notice, conduct that that the actual person knew about it, that reflected unfavorably upon them. That evidence, we're dealing with sufficiency of the evidence, that type of conduct was before the court. And so even though the letter was submitted after the fact, it was brought in to show not to the truth of the matter asserted that, oh, this letter is after the fact, which triggered the notice, but the fact of this type of conduct was ongoing. That conduct was before the court. That conduct was reflecting unfavorably on Dolphin. And Dolphin was trying to show by virtue of the letter, oh yeah, this kind of verified what we're thinking, that, hey, this is unfavorable conduct. And that's, and that's why they need to be evicted, because we're dealing with the sufficiency of the evidence, and it's all they need to show is something. Do you follow my question?
I do. However, again, there has to be some sufficiency of evidence of why that default was entered. There was no testimony or evidence entered showing that there was any default or any unfavorable actions by the tenant, which would reflect unfavorably upon the landlord. The landlord was specifically asked whether he knew of any facts other than the notice from the airport, and he specifically said, no, I don't know of any facts or circumstances that were raised in that notice.
I think maybe where the confusion is, and reading through the transcript, it led me to believe that there was a concern, maybe perhaps the judge felt that there should have been evidence presented regarding some of these wrongful acts. There has to have been evidence of these wrongful acts, but that really is not the case, because given the lease provision being so broad, there could be any little thing presented to the court saying, hey, this is unfavorable. I am under the impression this is unfavorable conduct. I have the right based on this. It could be anything. And therefore, what I have that is, and I guess what I'm concerned with is, like, if you look at the letter itself indicates that, as you are aware, the past 6 years have witnessed a steady stream of repeated rule violations. So that evidence that it's not like, oh, the letter came after the fact. We're dealing with conduct that has been happening in the past 6 years. So it's unfavorable conduct, and that evidence is before the court. And we're dealing with the sufficiency of the evidence on an involuntary dismissal. Why isn't that sufficient to withstand that?
Well, again, because that was all those suggestions were hearsay. They were statements made by the airport authority where
it's in evidence. I mean,
it is,
all that may be true, but it was received, right?
It was, and it was received after the notice. If we're going to look at the lease specifically says that if the landlord determines that there's a breach because the lessee operates its facility in a manner that reflects unfavorably, then the lessor should have the right to terminate this lease upon 30 days written notice. The issue here is that there is no testimony or evidence that it was operated in a way that was unfavorable prior to receipt of that notice. The letter was admitted only for the mental impression on the recipient subsequent to the time that it was received.
I know, but it's the impression. I did this letter, and it's impression on me that I now know that this conduct has been happening for 6 years. That's reflecting. The letter basically was the icing on the cake. Hey, do something about this, and that's what then. I mean, when the actual eviction termination started happening, is that this conduct has been ongoing, and so. When I say there's been some evidence presented before the court, some evidence is before the court, and I guess what I can't get around the fact as unfavorable conduct, it's very, very broad, very, very broad. And so if that letter was not in evidence, I think you'd have a stronger case. But the letter is in evidence. And so this is where I'm struggling with, Mr. Eisman. Help me out.
Well, and again, the discretionary termination, even though it's broad or solely in the determination, there's still that understanding that it can't be for anything. It can't just be for, because the sky's gray, sky's blue, the landlord doesn't feel like he wants his tenant around anymore, so we're going to use the discretionary determination to come up with anything. There still has to be some kind of facts that are presented before the court to show that the facility was operated in an unfavorable manner. None of the factors listed in that letter were admissible. The court did not consider those because they were considered hearsay. So all we had was a letter that was received subsequent to this notice, and their only witness never testified as to any of the actions that occurred prior to the breach notice being sent. So before the court, there was nothing before the June breach notice that reflected anything unfavorably, which would give rise to a discretionary termination.
I know I peppered you with a lot of questions, Mr. Eisman, but feel free to go forward.
I think that's, really all about all that we have. It was a involuntary dismissal based on the lack of evidence. That they didn't prove their case. They didn't prove the breach of the lease. The notice was sent, which was a requirement under the lease, and they had to prove that prior to that notice being sent, there was some breach, which the court simply did not find. He said, based on the evidence testimony, there is nothing in front of me that's been admitted that shows that there was any rules or regulations violated, or that there was any, actions that were taken by the tenant that were unfavorable to the landlord.
Okay. Thank you. Anything further, Mr. Eisman, at this time?
No, Judge.
Very good. Thank you. All right. Mr. Rocknish, you have your rebuttal time, sir.
Thank you, Your Honor. I would like to take exception with the point that some breach has to be proved, because that's not what the discretionary termination provision states. But I also like to address the timing issues, because in the record, it's at page 103, and it's an attachment to the letter that Dolphin Aviation received. And it's the Sarasota Manatee Airport Authority Police Department report. It says Nicholas Hurley, Heli Aviation. And it says on May 27th, 2019, case number, aggravated assault, Hurley pointed loaded firearm at customer while inside heli aviation at the hangar. And then it says Hurley arrested on warrant for aggravated assault on June 3rd, 2019, pending arrest warrant for grand theft, July 11th. These were actions, obviously, that it's Dolphin Aviation's leased land isn't that big. When incidents like this happen, obviously everybody at the location knows there's something happening. And the fact that the letter came after the notice is really irrelevant, because the court in the transcript says that it recognized that there were arrests pending. So these are not that even that Dolphin needs to prove that there was conduct that reflected unfavorably, because I think the discretion is broader than that. But we brought this letter and admitted it to evidence to show why they took the steps they did as a landlord, because of course landlord doesn't want to get rid of tenants, but in a situation like this, they had no options but to do so. And I do want to say that there was a point raised on the provision not saying it's solely in the landlord's discretion. There isn't anyone else. It says discretionary termination, and there's only two parties, the landlord and lessee. So it's inherent in the language that it's the landlord's discretion. Again, there's no claim that the term was unconscionable, and it's what the parties bargained for. And for that reason, we respectfully request this court to reverse the order of dismissal with prejudice and remand for proceedings consistent with Richter and Hahamovich, where the terms of the contract are enforced. Thank you, Your Honor.
Thank you both. Again, well argued on both sides. Thank you all. So at this time, I think this concludes our very last case. So thank you, gentlemen. If you could just now sign off, the court will be signing off at this time. Thank you.
Thank you.
Thank you.